So, a little bit about this permanent injunction, and by a little bit I mean I'm going to read the entire thing. So, filed October 26, 2017, permanent injunction on ballot question 2A, filed in the 10th Judicial District of the State of Colorado. Jonathan Masters, a citizen of Pueblo City, plaintiff v. the government of Pueblo City, Colorado, defendants, complaint for permanent injunctive relief. Introduction. Ballot question 2A in the upcoming November 7th, 2017 Pueblo City general election is titled Charter Amendment Change Form of Government to Mayor-Council. Ballot question 2A has been nicknamed the Strong Mayor ballot question. Ballot question 2A is over 400 words long. The ballot question corresponds to a 10-page document which includes 70 changes to the 1954 Charter, including changes to all three branches of the government of Pueblo City. The main changes for ballot question 2A is the change in the name of the chief executive and the manner in which the chief executive is elected. Ballot question 2A is going to change the name of Pueblo's chief executive from city manager to mayor. In this document, chief executive is used for both positions. Charter commission and charter convention is also used interchangeably. Per the 1954 Charter, Pueblo City's chief executive is currently not popularly elected. The 7 members of City Council are popularly elected, and then City Council, by majority vote, hires and fires the city manager at will. Ballot question 2A changes that. Ballot question 2A requires Pueblo City's chief executive to be popularly elected every 4 years after the first 5-year mayoral term, beginning next year, to be elected in the November 2018 general election. Many of the 70 proposed changes simply replace city manager with mayor. The current powers of the city manager and the mayor's proposed powers in most respects stay the same. They are both Pueblo City's chief executive. Neither have a vote in city council. The budget starts with them. They hire and fire nearly all the city employees without city council interference. Both have the exclusive power to give direct orders out to all the city employees, which the city council is strictly forbidden to do so. Both have to write an annual state of the city report and an annual budget report. The proposed mayor will have a veto, whereas the current city manager does not. The proposed mayor cannot be fired by the city council, whereas the current city manager can be at will with a simple 4 of 7 majority vote. City council is stripped of their firing the chief executive power, which is a substantial weakening of the legislative branch and strengthening of the executive branch. The veto power also increases the mayor's power, since city council must wait until the next city council meeting to overrule that veto, but some of the chief executive powers have been cut. The proposed mayor can't sign surety bonds anymore, Section 314, whereas the current city manager can. The current city manager can hire and fire everybody, including department heads, without city council interference. Ballot question 2A gives city council confirmation powers for department heads that the chief executive nominates, increasing the power of city council and lessening the power of the proposed mayor. Ballot question 2A proposes to change all 3 branches of Pueblo City's government. While substantial changes to the executive branch have been the main focus of ballot question 2A 2017, the powers of the legislative and judicial branch have also been changed too, significantly. Per the 1954 Charter, Pueblo City Council currently hires and fires the municipal judges unilaterally, without interference from the chief executive. Ballot question 2A proposes that the chief executive wins the sole nomination power of new municipal judges, with city council merely confirming them. The mayor would also have absolute power over the firing of the municipal judges. City council won't be able to hire and fire the chief executive and the municipal judges at will anymore under ballot question 2A. All motions, ordinances, and resolutions of city council can be vetoed under ballot question 2A. Ballot question 2A also proposes some seemingly minor, albeit curious, changes. The aviation department is now governed by ordinance instead of resolution, Section 14-1. A Purchases and Supplies Department is being added, Section 728. Section 6.4 eliminates a specific 60-day provision and adds a curious or by a city employee acting within the course of employment clause. jurisdiction and venue. The 10th Judicial District has original jurisdiction over the constitutional matters of determining what powers are in Pueblo City's domain and what powers Colorado's legislature has. Home rule cities, in general, handle local issues, and the state handles issues of statewide concern, governed by general state legislation, and state courts determine that distinction. Denver v. Balsey, 1928. Hershey v. McNichols, 1932. Article 20, Section 6 of Colorado's Constitution was added in 1912, which makes all post-1912 Colorado Supreme Court cases relevant. Parties. Plaintiff Jonathan Masters is the city of Pueblo City who will be affected by ballot question 2A. Defendant, the government of Pueblo City. The city council, city manager, and the city clerk, with the consent of the city lawyer, placed ballot question 2A on the ballot. Nature of action. Ballot question 2A is unconstitutional. Therefore, a permanent injunction on ballot question 2A must be issued and entered into record. Legal background. Ballot question 2A is unconstitutional on its face. Pueblo City's 1954 charter is Pueblo City's organic law, and it extends to all its local and municipal matters. Pueblo City, by virtue of Article 20, Sections 1, 4, and 5, gets all the essential and indispensable powers necessary for the government of its local and municipal affairs, including the power to amend, add to, or replace the charter. Emphasis added of Pueblo City, which shall be its organic law and extend to all its local and municipal matters. City and County of Denver v. Mountain States Telephone and Telephone Company, 1919. Home rule cities have a major stake in writing and abiding by their own local charter. The 1912 Home Rule Amendment extends Pueblo City's municipal power as broad as possible within the scope of a Republican form of government of the state. Per Justice Dennison, the Home Rule Amendment was intended to reiterate unmistakably the will of the people that the power of a municipal corporation should be as broad as possible within the scope of a Republican form of government of the state. Emphasis added and viewed in that light is a valuable guide in interpreting the 20th Amendment. Fort Collins v. PUC, 1921. I like that quote enough, I'm going to repeat it. So this is Justice Dennison. The Home Rule Amendment was intended to reiterate unmistakably the will of the people that the power of a municipal corporation should be as broad as possible within the scope of a Republican form of government of the state. And viewed in that light, it is a valuable guide in interpreting the 20th Amendment. The 20th Amendment would be the Article 20, which is the Section 6, Article 20, was 1912 Home Rule Amendment. So it strengthened the 20th Amendment. But he's saying the Home Rule Amendment, very clearly, since it was added to the 20th Amendment, means that it's state power. So they should have as much power as a government gets in a republic. In the 1962 four-county metropolitan case, the state court decided that home rule cities in Colorado and local matters had complete absolute plenary authority. Therefore, municipal policy exercised by a home rule city in Colorado is the equivalent of state action when exercised in connection with municipal affairs. Four-county metropolitan capital improvement district v. Board of County Commissioners, 1962. The 1954 Charter of Pueblo City begins with a preamble. After the preamble, there's Section 1.1, and Section 1.2 is situated right after Section 1.1. Per the first sentence of Section 1.2, Pueblo City's form of government, named the council-manager government, shall not be changed except by charter convention upon majority vote of the qualified voters. Pueblo City's founding fathers added the high threshold of a charter convention in order to protect Pueblo City's council-manager system. Section 1.2 clearly states that the only way Pueblo City's form of government can be changed as by way of a charter convention. Ballot question 2A instead proposes to change Pueblo City's form of government to mayor-council by ballot question, not by the constitutionally required charter convention. In order for Pueblo City to replace the city manager with a mayor, a charter convention must be convened. In order for a charter convention to be convened, the people of Pueblo City must vote for a charter convention first. Without a charter convention, Pueblo City cannot change her form of government. Instead of abiding by the charter convention clause, the government of Pueblo City is attempting to change our form of government illegally and unconstitutionally by way of ballot question 2A. After ignoring the charter convention clause, section 1(2) as one of the 70 changes ballot question 2A proposes, ballot question 2A adds insult to injury by gutting out the charter convention clause from Pueblo's current governing charter altogether. The charter convention clause of section 1(2) gives Pueblo City double protection for our home rule status. By stripping section 1(2) out of Pueblo City's 1954 charter, Pueblo City's independent constitutional standing will now be solely dependent on the restraint of the state. State power v. local charter power. Much of the debate between the gray twilight zone area of statewide powers versus local powers have been determined by the state courts. In general, the state concerns itself with statewide concerns. The local government concerns itself with local concerns. Here's a list of 10 areas state courts have determined to be of local concern, not state for home rule municipalities. Number 1, municipal courts. People ex rel. McQuaid, 1932. Hardeman v. Municipal Court, 1972. Number 2, local land use and zoning. Roosevelt v. City of Inglewood, 1971. City of Colorado Springs v. Smart, 1980. Vista Village v. City of Boulder and Boulder Builders v. City of Boulder. 3, capital improvement construction. Davis v. City of Pueblo, 1965. 4, County Metropolitan Capital Improvement District, 1962. Berman v. Denver, 1965. Number 4, election and recall. Laverty v. Straub, 1943. International Brotherhood of Police Officers, Local 127 v. Denver, 1974. Bernzen v. City of Boulder, 1974. Number 5, broad employee regulation, including municipal employee residency requirements. City and County of Denver v. State of Colorado, 1990. 6, theft of items under $300. Haddock, 1990-2. 7, public right-of-way franchises. City of Greeley v. Poudre Valley Rural Electric, 1987. City of Montrose v. PUC, 1987. 8, police courts. Blackman v. County Court, 1969. Huff v. Police Court, 1971. Number 9, taxing for revenue. West Coast Advertising Company v. City and County of San Francisco, 1939. And 10, broad condemnation of property power. Article 20, Section 1, City of Thornton v. FRICO, 1978. Home rule cities have plenary legislative authority over matters exclusively local in nature. Plenary means absolute. Plenary means absolute. McNichols v. City and County of Denver, 1937. City and County of Denver v. Palmer, 1959. Kelly v. City of Fort Collins, 1967. Number 1, liquor regulation. Colorado Constitution, Article 22. 2, utility charges and rates. PUC v. City of Durango, Denver v. PUC. 3, felonies. City of Aurora v. Marin, 1973. And 4, certain other criminal acts. Gazzotti v. Denver, 1960, are 4 areas Colorado courts have determined to be of statewide concern. Let me repeat those. There's 4 areas the state courts have determined to be of statewide concern. Those are liquor regulation, utility charges and rates, felonies, and certain other criminal acts. The 10 areas state courts have determined to be of local concern is municipal courts, local land use and zoning, capital improvement construction, election and recall, broad employee regulation, including municipal employee residency requirements, theft of items under $300, public right-of-way franchises, police courts, taxing for revenue, and broad condemnation of property power. Local home rule immunity can be easily overridden by a state statute, treating the policy problem as one of statewide rather than exclusively municipal concern. Colorado's legislature may enact overriding provisions where there is a question of public policy. Cities have exclusive and absolute and plenary dominion over the construction of our own local charters. The powers of a chartered municipality are part of the constitutional powers granted to the home rule city by the people. Pueblo Aircraft Service Incorporated v. City of Pueblo, 1980. The powers of a chartered municipality are part of the constitutional powers granted to the home rule city by the people. When designing a charter, common sense dictates that it is incumbent upon the city herself to design the best system of government for herself. When designing a charter, common sense dictates that it is incumbent upon the city herself to design the best system of government for herself. The state legislature may act as a guide, but Section 1.2 constitutionally guarantees Pueblo City's right to conduct her own charter conventions. In addition to being a constitutionally protected right, Pueblo City has an inherent right to write our own governing constitutionally protected charter. It is natural to a republic to have only a small territory, otherwise it cannot long subsist. In a large republic, the public good is sacrificed to 1,000 views. It is subordinate to exceptions and depends on accidents. In a small one, the interest of the public is easier perceived, better understood, and more within the reach of every citizen. Charles de Montesquieu, from the Spirit of Laws, Chapter XVI, Volume 1, Book VIII, 8, as quoted by the anti-federalist Brutus I. By design, a city charter is purely local in nature. A local governing municipality, county, town, city, or village must create the best governing charter it thinks best for its own local interest. That's obvious. On its face, it's common sense. Article 20, Section 6 is self-executing. Section 1.2 of the 1954 Charter is a clear expressed power protected constitutionally. Section 1.2 isn't an implied power or a power incident to Section 1.2. Instead, is a clear expressed power. The requirement of a charter convention in Section 1.2 to change Pueblo City's government is narrowly constructed, and the wording and their definitions and their clear express intent is extremely clear. We Puebloans can only change our charter by a charter convention, not now nor ever by mere ballot initiative. Neither an act of legislature, referred or unreferred, nor an initiated law, emphasis added, can recall any power or privilege granted by the Constitution. Fort Collins v. Public Utilities Commission of Colorado, 1921. There's no specific details in the 1954 Charter for how a charter convention is supposed to be conducted, which allows for the people of Pueblo City to conduct our own charter convention however we see fit. A fundamental governing principle of democracies the world over is that ultimate sovereignty resides in the people. Democracy is a government of, by, and for the people. Article 2, Section 1 of Colorado's Constitution declares that all power lies with the people. All political power is vested in and derived from the people. All government of right originates from the people, is founded upon their will only, and is instituted solely for the good of the whole. The Cooley Doctrine says that cities have an inherent absolute right of self-rule and the state cannot take it away. The state may mold local institutions according to its views of policy or expediency, but local government is a matter of absolute right and the state cannot take it away. It would be boldest mockery to speak of a city as possessing municipal liberty where the state not only shaped its government, but at discretion sent in its own agent to administer it, or to call the system one of constitutional freedom under which it should be equally admissible to allow the people full control in their local affairs or no control at all. Leroy v. Hurlbut, 1871. Thomas M. Cooley relied on Alexis Tocqueville and his Democracy in America for his defense of local government. Tocqueville admired the autonomous authority of local government in New England. The township of New England is so constituted as to excite the warmest of human affections without arousing the ambitious passions of the heart of man. In the township, as well as everywhere else, the people is the only source of power. Home rule cities fosters active civic responsibility among the local citizenry. If the municipal bodies were made powerful and independent, the authorities of the nation might be disunited and the peace of the country endangered. Yet without power and independence, a town may contain good subjects, but it can have no active citizens. Tocqueville, Public Spirit of the Townships of New England, Democracy in America. Even right-wing conservative John Forrest Dillon said that eliminating local governments would be so great a folly and so great a wrong. City of Clinton v. Cedar Rapids and Missouri Railroad, 1868. Colorado Constitution establishes her love of independence in her preamble in order to form a more independent and perfect government. Pueblo City's home rule status is constitutionally protected, but not democratically protected. The wellspring of democracy springs from the people, and cities are chock full of people. People are the heart and soul of democracies the world over. Pueblo City, by the virtue of being a city filled with the sacred and sovereign people, therefore has all the powers that extends to a republic. All power belongs to we the people, but we the people can lose our democracy if we become complacent. Eliminating the Charter Convention Clause deprives ourselves of one protection for our autonomy, freedom, and democracy, i.e. our home rule status in Pueblo City. Precisely 100 home rule cities and one territorial charter municipality, Georgetown in Colorado, enjoy very strong constitutional home rule provisions. Article 20, Section 6, Clause 5 of Colorado's Constitution protects the full right of self-government of Pueblo City in both local and municipal matters. It is the intention of this article to grant and confirm to the people of all municipalities coming within its provisions the full right of self-government in both local and municipal matters, and the enumeration herein of certain powers shall not be construed to deny such cities and towns and to the people thereof any right or power essential or proper to the full exercise of such right. Article 20, Section 6, Clause 5. Pueblo City shall have all the powers granted to municipal corporations and to cities by the Constitution and general laws of this state, plus all the implied powers granted. The 1954 Charter reconfirms our right to self-government when it declares that the City of Pueblo shall have perpetual succession. Section 1.3. There's at least two clauses in Article 20, Section 6 that makes Pueblo City's constitutionally protected home rule status particularly robust. Article 20, Section 6, Clause 2 declares that the ordinances and statutes of Pueblo City shall supersede any law of the state in conflict therewith. Clause 6 of Article 20, Section 6, Clause 6 of Article 20, Section 6 doubles down on how Pueblo City's local laws supersede state law. The statutes of the state of Colorado, so far as applicable, shall continue to apply to such cities and towns except insofar as superseded by the charters of such cities and towns or by ordinance passed pursuant to such charters. Article 20, Section 6, Clause 6. In Colorado, charter law is superior to and takes precedence over state law, especially in purely local matters. Vila v. People, 1971. DeLong v. City and County of Denver, 1978. Boulder County Apartment Association v. City of Boulder, 2004. The Appeals Court. Binion v. City and County of Denver, 1972. REN v. City of Colorado Springs, 1992. City and County of Denver v. Quest Corporation, 2001. Winslow Construction Company v. City and County of Denver, 1998. The State's Charter Commission. Article 20, Section 6 of the current 1876 Colorado Constitution lists 8 specific constitutionally protected home rule powers. Pueblo City does not derive her power from the General Assembly. Pueblo City's home rule status is created by Article 20, Colorado's 1912 Home Rule Amendment. So Article 20 is the 20th Amendment. The Home Rule Amendment is Article 6 or Section 6 of Article 20. Burks v. City of Lafayette, 1960. Colorado Home Rule City's inherent election powers is codified and institutionalized into law by Article 20, Section 6D, the strongest plank of the list of 8 constitutional home rule powers protected by Colorado's Constitution. D. All matters pertaining to municipal elections in such city or town and to electoral votes therein on measures submitted under the charter or ordinances thereof, emphasis added, including the calling or notice and the date of such election or vote, the registration of voters, nominations, nomination and election systems, judges and clerks of election, the form of ballots, balloting, challenging, canvassing, certifying the results, securing the purity of elections, guarding against abuses of the elective franchise, intended to make such elections or electoral votes nonpartisan in character. That's Article 20, Section 6D. Pueblo City has constitutionally protected authority to handle all matters pertaining to her own elections, and Article 20, Section 6H protects a chartered home rule city to impose fines and penalties for the violation of any of the provisions of the charter or of any ordinance adopted in pursuance of the charter. While the 1954 charter doesn't provide any guidelines for how charter conventions in cities should work, the state offers micromanaged and detailed suggestions with CRS 31.2.204, 31.2.206, 31.2.207, and 31.2.210. First, the voters of Pueblo City vote for a charter commission. Voters in Colorado's home rule cities can either get a charter commission by petition or by city council ordinance. The easiest and quickest way to initiate the process for a charter commission would be by city council ordinance. 2/3 of city council must vote for the charter commission ordinance, 31.2.210, 2B. 2/3 of 7 is 4 2/3, which rounds up to 5. The charter convention process can be initiated by 5 votes from the 7-member city council of Pueblo City. If Pueblo's city council fails to pass an ordinance for a charter commission, then the people of Pueblo City can bypass the charter commission on the ballot by petition. The petition must be signed by at least 15% of the registered electors of the municipality. 31.2.210, 2A2. If the voters approve of a charter commission, then Pueblo City's voters will need to vote for delegates for that charter commission in a delegate election. Within 30 days of initiation, the governing body must call an election to form the charter commission and elect members of the commission, and then that election must be held within 120 days of the call of the election. CRS 31.2.2042. All registered electors of the municipality are eligible, and any vacancy on the charter commission shall be filled by appointment of the governing body. 31.2.210.3. Those who are interested in being a delegate for the Charter Convention must file a sufficient petition with the clerk within 30 days of publication of the election notice, signed by at least 25 registered electors.